All right, let's turn to this now. And marriage officers in the public sector could soon lose their ability to ask for exemption from officiating same-sex marriages on the grounds of their religious beliefs. This after the National Council of Provinces this week passed the Civil Union Amendment Bill. If signed into law, the bill will remove the so-called conscientious objector exemption, which has until now allowed marriage officers to ask the Minister of Home Affairs to excuse them from solemnizing gay marriages if they compromise their religious convictions. The new bill is a double-edged sword, though, as it advances the rights of same-sex couples to fair access to public services, but at the same time it faces objections on grounds that it will violate the religious rights of public servants. Joining me now for a discussion via Skype is constitutional law expert, that's Pierre de Vos, and Freedom of Religion South Africa's Mike Swain. Thank you so much to the both of you for joining me. Let me start with you, Pierre de Vos, and ask you about the significance of this. I mean, that accommodation that if a marriage officer views same-sex marriages as being not in line with their religious beliefs was something of a compromise from the Fourie judgment and also the Civil Union Act coming into being. How significant is it that it's now being moved by these legislative developments?
Yes, it's significant because the provision as it stood was obviously discriminating in an unfair way against gays and lesbians. The same provision is not available or was not available for people who objected to other people's marriages on other grounds. For example, if you're of a certain religion, you're objecting to inter-religious marriage or whatever the case might be. So this just normalizes the situation so that same-sex marriages are treated exactly like any other marriage, because it is like any other marriage. And so for that reason, it is quite a significant thing, but it's also practically significant because especially in smaller towns and so on, it was very difficult sometimes for same-sex couples to get someone to marry them because most of the officials refused to do so, allegedly on the religious grounds.
What's your take, Michael Swain, from Freedom of Religion South Africa? Of course, this had to do with not putting the members of the civil service to the difficulty of having to choose between performing their functions ex officio and being true to their religious tenets. What does this mean then, from your perspective?
I think this is a very unfortunate decision and arguably an unconstitutional outcome, because Justice Albie Sachs in the Fourie case, which was the case which really told Parliament that they had to recognize the equality rights of same-sex individuals, stated that, and I'm quoting, the principle of reasonable accommodation could be applied by the state to ensure that civil marriage officers who had sincere religious objections to officiating at same-sex marriages would not themselves be obliged to do so if this resulted in a violation of their conscience. And it was a consequence of this statement in the judgment by Justice Sachs that led to Section 6 being included in the Civil Union Act. So the fact that it's now been removed, it doesn't actually add anything more to the rights enjoyed by LGBT couples. It simply takes away the rights from state marriage officers who sincerely object on the grounds of conscience and belief from being able to have their equality rights respected. So this is actually, in our view, a very negative decision when it comes to freedom of religion rights. And it is unfortunate because it does not reasonably accommodate those rights. It really is a winner-takes-all, which in a society which is supposed to be diverse and where we celebrate diversity, this is not a good outcome for equality rights.
But do you appreciate what, if I stick with you, Michael Swain, do you appreciate what Professor Pierre de Vos says about the difficulty that this exemption was presenting for same-sex couples in more remote areas where perhaps, and arguably in some contexts, attitudes could be said to be a bit, conservative? conservative, where you will have a large number of people saying, a large number of state officials saying that this is against my religious beliefs, with the result that, while on paper the right to get married in terms of the Civil Union Act was there for same-sex couples, but in practice, in many instances, it was possibly being taken away by this exemption.
I think importantly, it was a practical problem which demanded a practical solution by the state. So, for example, in remote areas, you also have, say, roving courts. You have circuit judges which go to certain places at certain times. Or alternatively, you can employ people who specifically, as state marriage officers, have no problem with their conscience when it comes to solemnizing same-sex marriages. So this was actually something which could have, and we believe should have, been solved in a practical way by the department, rather than simply now removing the sincerely held religious freedom rights from state marriage officers, who, just because you work for the state, doesn't mean to say that as an individual you now lose all your constitutional rights. So I think this is just a very unfortunate and not a very good decision at all.
Pierre de Vos, let me ask you, in terms of how, if you think about the rights in our constitution, and particularly the right to freedom of religion, and linking that to human dignity, that it seems you are closer to the core of the right to human dignity when you're talking about the issue of the right to freedom of religion. Surely there's an argument to be made there that putting marriage officers who happen to work in the civil service to that painful choice between being true to their religion or being true to their functions is an untenable situation.
No, I think there's a profound double standard at play, because already the law does not permit civil servants who have specific religious objections to various things to object to that and to opt out. So if you're in a religious institution and your religious institution says you're not allowed to interact with women, you cannot work for the state, because the state says you cannot go at home affairs and then only decide to serve men. So it's only for sexual orientation where the exception has been made in the past. And why is that? Because symbolically it says that the state does not take discrimination against gay men and lesbians as equally important as other kinds of discrimination. That has now been equalized. So people with religious beliefs who work for the state are now treated the same, regardless of what their religious beliefs say they should and should not do. And at home, they are still allowed, and in any other public sphere, they are still allowed to believe and to practice their belief in exactly the same way.
So from your perspective, Professor de Vos, is there no stumbling block to the president putting signature to this bill and bringing it into effect?
No, because the judgment that the other participant referred to didn't say that it is required for this to happen. It uses the concept of reasonable accommodation. I think given the practical problems and given the fact that any kind of different treatment is going to send a signal that LGBT people are less of respect and concern, all of that means that there is no reasonable way in which the religious beliefs here can be accommodated, unless you accommodate every religious belief and allow every civil servant to refuse to do certain tasks because of whatever religious belief they might have on a specific issue.
Michael Swain, should the president put pen to paper and sign this bill into law?
Well, we would say not, and also specifically for the fact that the Department of Home Affairs is currently conducting and has been conducting a nationwide analysis and developing a policy for marriage laws as a whole in South Africa. So this is a situation which is already under review. There is a process under review. Why amend a law right now, in any event, when this whole thing is up for discussion and up for great amount of public debate? There will be a new Marriage Act forthcoming, and we believe that this is therefore a premature decision, and it should be at least held over until the whole process of developing a new Marriage Act is concluded.
Yeah, in fact, if I come back to you, Pierre de Vos, Michael Swain brings me to that point about having two separate regimes for marriages for same-sex couples versus, heterosexual couples. I sort of get the context in which, it was arrived at the whole debate in society at the time of the Fourie judgment and the subsequent passing of the Civil Union Act. But what is your sense in light of the, upcoming review of the marriage laws? Because the consequences are the same, whether you get married in the Civil Union Act or you get married in terms of the Marriage Act, you are married. What should be the approach going forward in as far as perhaps working within one law?
Yes, so I think that actually the existing legal arrangement is probably still unconstitutional, because when the court ruled on this initially, they said maybe one option would be to have a marriage act where everybody can take part in, and then you have specific marriage acts, for example, that only religious people could do, but that would be an add-on. Everybody normally would just get married under the Marriage Act, gay, straight, whatever. So I think there should be one marriage act. There could be different provisions for different consequences, whether it's a customary marriage, whether it is another religious marriage, or whatever the case might be. But if you don't have that, it is very difficult to actually respect the right not to be discriminated against on various grounds, including sexual orientation.
All right, thank you to the both of you. That is Michael Swain from Freedom of Religion South Africa and Professor Pierre de Vos weighing in on the developments coming out of the National Council of Provinces in as far as the Civil Union Amendment Bill is concerned.